sir. Okay. So good evening aspirants, welcome to MVC Academy. So today you have answered the Indian Polity Test 2 questions. So just check the key and explanation part here. So first of all, first question, that is, consider the following statements regarding the zonal councils in India. So a very important question here. So they are constitutional bodies established under Article 263 of the Constitution. It has given like this. So Union Home Minister acts as the common chairman for all the zonal councils. So here we have to understand the zonal councils. What is the need of zonal councils here? So whenever we got independence, after independence, we have so many issues like linguistic hostilities or some other issues, right? So here two cooperation issues also there were there at the time of independence, after independence, right? So at that time they have initiated these zonal counts to promote cooperation in between the states, among states and center and states, right? So these are not constitutional bodies, but they have the statutory bodies, right? So statutory bodies only. Why? Because they have enacted a law, particularly. What is that? State Reorganization Act 1956, right? So this is very important here. So that's why they are not constitutional bodies. This, if you observe this statement, so completely this statement is related to interstate council, right? Not zonal councils here, right? Why? Because it is mentioned like Article 263, that is related to interstate councils, right? So Union Home Minister here. So here we have mainly five zonal councils, one at Delhi, right? That is headquarters, right? So remaining are regional, like we have in Allahabad, or we have the Kolkata and Mumbai and Chennai, right? Other than this, one other additional special regional body is also there, right? Council also there, that is Northeastern Council, right? Northeastern Zonal Council was also there, right? So apart from that, coming to the composition here, so Union Home Minister acts as the common chairman for all zonal councils here, whatever we have. So apart from that, here each state CMs especially, right? CMs are also members, but so specifically here, particular CM, this particular zonal council meetings are conducted as rotational wise, right? So wherever it is conducted related to the situation, so this particular state CM will be the vice chairperson here, right? So chairperson is every time Union Home Minister, right? So this second statement is correct, first statement is wrong, right? So only 2 is the correct option. Next important, with reference to the concept of basic structure of the Constitution, consider the following statements. So what is the basic structure of the Constitution here? So we have familiarly in the Constitution, it is very important, right? So the doctrine was first propounded by the Supreme Court in the Golaknath versus State of Punjab case, right? So this was completely wrong. So it was first propounded by Keswananda Bharati versus State of Kerala, right? So 1973. But Golaknath versus State of Punjab case, what was mentioned here? Supreme Court clearly stated that here. So the state cannot, or Parliament, we can say, right? Parliament cannot abridge any of the fundamental rights. That was given exclusively related to the Golaknath versus State of Punjab case, but not was propounded by the Supreme Court here. Doctrine, this basic structure was not propounded by this particular case, right? That is 1961 only, right? So this statement is wrong. Doctrine implies that Parliament cannot amend the fundamental features of the Constitution here. So what are the features of the Constitution here? So especially related to basic structure, Parliament do not have the authority to amend the particular basic structure. Basic structure means here we have certain elements, judicial review we have, federalism we have, and also some constitutional procedure like this we have, and also apart from that we have some fundamental rights we have. Apart from that we have certain important issues, rule of law, right? So all these are important elements. These are not permanent here. These are not permanent. Time to time or based on the situation, court can extend the list of those elements related to the basic structure, right? So that's why Parliament cannot amend the fundamental features of the Constitution, but they can amend the Constitutional Amendment Acts, right? So that is completely different. But these fundamental features of the Constitution means basic structure of the Constitution, doctrine, right? So this is right. So specific elements constituting the basic structure have been exclusively defined by the Supreme Court. So this statement, if you observe, so specific elements constituting the basic structure exclusively, exhaustively defined by the Supreme Court, it was not correct. Why? Because it was not completely defined by the Supreme Court, just they have given some list, right? But based on the time to time or based on the situation, they can extend the list, right? So this is not correct. So if you observe this, only one means here the second statement only is the correct answer, right? So next, consider the following statements regarding the powers of the President of India. So as we know, regarding the constitutional powers or authorities, President and Governor has so many powers, right? So President can dissolve the Lok Sabha before the expiry of the term on the advice of the President, Prime Minister. So it is completely correct. If you see the article 85, right, completely related to the dissolution of the Lok Sabha based on the advice of the Prime Minister, right? So President can summon a joint sitting of both houses of Parliament for a money bill. So if you observe, so whenever we are talking about money bill, there are certain restrictions, right? So here not money bill. President can summon a joint sitting of both houses of Parliament for ordinary bill, or it can be financial bill, right? So but President cannot summon a joint sitting for both houses of Parliament for money bill. If you observe, why, what is the need for joint sitting? Whenever there is any deadlock or conflict between these regarding any bill in between both houses, then completely the President can summon this joint meeting, right? So but here coming to the money bill, there is no need to conflict, no need to come any conflict related to that, right? Why? Because so many powers are under the Lok Sabha only, right? So this is completely wrong, right? So President can make regulations for the peace, progress and good government of Andaman and Nicobar Islands. So this is absolutely correct. Why? Because this is according to the article 240. So Union territories relatedly, President can make regulations for the peace, progress and etc., right? So this is correct. So President is not bound to give assent to a constitutional amendment bill. Is it correct? So not bound. So previously we have certain limits, means if you observe the 24th Constitutional Amendment Act, so 1971, if you see, before 1971 there was no constitutional obligation, but 24th Constitutional Amendment Act changed everything. So President, from this constitutional amendment, President is bound to give assent to a Constitutional Amendment Act, right? So this is completely wrong, right? So if you check the key here, so the answer given like only 3, but here I am changing this third question. For third question, the answer is only 2, right? So means here first option and 3 option, right? Only 2 is the correct answer, not C. Only 3 is not correct, right? So next, which one of the following statements about Finance Commission is not correct here? It is a quasi-judicial body. Is it a quasi-judicial body or not? Constitution constituted by the President of India every 5th year or earlier, right? So this is absolutely correct. So Finance Commission, if you take Finance Commission, completely 5 years term, tenure is there. So and also quasi-judicial body, right? So it is a constitutional body established under Article 280. If you see the Election Commission or CAG, or we have the Finance Commission, all these are constitutional bodies only. We have already discussed in the previous videos. If you have not seen, please check those videos, right? So it makes recommendations on the distribution of net proceeds taxes between union and states. The major role and responsibility is this is only, right? So this is correct. Its recommendations are binding on the government of India. So if you check the constitutional obligation, if you see the entire constitutional provisions, no authority is having binding powers on the government, right? So majorly, right? So here recommendations are not binding, but rather than they are advisory only, right? We have to understand, right? So Finance Commission under Article 280, it was constituted as a constitution body, right? So only C is the not correct. They have asked only for not correct. C is the correct option. So next, with reference to the doctrine of pith and substance, consider the following statements. So it is a judicial principle used to determine the legislative competence of the parliament and state legislatures. It is applied, etc., etc. It was there. So I don't want to waste your time by reading all the statements here. I just explained. So if you observe previously, means in the previous test 1, we have discussed doctrine of harmonious construction. What is doctrine of harmonious construction? In constitution, we have number of provisions. Wherever there is any conflict between 2 or more provisions, then judiciary will involve. Judiciary intervention is there, will be there, right? So that is called doctrine of harmonious construction, right? So likewise here, doctrine of pith and substance is completely related. Wherever there is a conflict happened between the center and state legislations on the matters of the subject related to the legislation of that particular matter or state or center, right? So here doctrine of pith and substance determines the nature of the law, whether it is under the jurisdiction of that particular center or state, right? It is completely focused on this, right? So doctrine of pith and substance, it is a judicial principle used to determine the legislative competence of the parliament and state legislatures. That is correct. And also it is applied when a law enacted by one legislation incidentally encroaches upon the field assigned to the other legislation. Means here, so if it is okay, whenever any law is enacted by the center or state, whenever sometimes it is completely encroached to another subject, right? So that is also it is applied here, right? So that is called doctrine of pith and substance. Means here, what is the meaning here? The nature, right? So the nature of law and character here. The nature and character of the law especially, right? So both two options are correct, right? So consider the following statements regarding the Right to Education Act, Article 21A, very important. So it was added to the Constitution by the 84th Constitutional Amendment Act 2002. It is very correct. So it makes free and compulsory education a fundamental right for all children between ages for 6 to 14 years, right? So it is also correct. The state is obligated to provide education in the manner it may determined by law. So this particular article included in the fundamental rights, whatever we have, right? For Article 21 is already we have. What is Article 21? Right to life and personal liberty. So Article 21 related to that, we have included number of provisions. Likewise, we have included our introduction of the due process of law, right? By the Maneka Gandhi case 1978, we have included number of rights in that, right? So apart from that, beside the Article 21 Clause A is separately included by the 86th Constitutional Amendment Act 2002, that is completely right to education, right? So if you see Article 21 is completely related to Article 21A is completely related to right to life, means here right to health, right to cleanly environment, right to pollution, anti-pollution, right, pollution-free environment. All these are included in the Article 21, right? So Article 21 is completely right to education. So state is obligated to provide this education free, right? So all these three statements are correct. So which one of the following statements regarding the Comptroller and Auditor General of India not correct, right? CAG is very important, that is related to Article 148, right? So CAG is approved by the President by warrant under the hand and seal, right? So CAG appointed by the President only by warrant under his hand and seal. right? So his tenure, if you see, the 6 years are up to the age of 65, whichever is earlier. If you compare with whatever we have discussed previously regarding the constitutional bodies, right? UPSC, right? If you see the UPSC or CAZ, all 6 years only, 6 years or 65 years up to age of 65 years, right? So especially chairman of UPSC says, right? So this is correct. This is also correct. CAG is audits all expenditure from the Consolidation Fund of India and Consolidated Fund of each state also, right? CAG is not only related to center, states accounts also. It will give audit, or it will audit the state accounts also. That's why here CAG is responsible for center through president here, right? State through governors, right? So why? Because CAG audits the accounts of the state here, right? CAG is responsible only to the parliament and not to the state legislatures. It is not correct. Why? Because CAG is responsible to state legislature also through the governor. First of all, he submits the reports to the governor. Based on that report, governor will set up that particular report, sends to the state legislatures especially, right? So this is not correct. That's why C is the correct answer. So next, consider the following statements regarding the National Commission for Backward Classes. So if you see that it was initially established as a statutory body but was later granted constitutional status. Is it correct? Yes, we have already discussed in the previous classes in the YouTube, right? So these are constitutional bodies, right? But initially it was statutory only. National Commission for Backward Classes Act 1993. From this act only it was created as a statutory body, right? So but later on it was granted constitutional status. From which act here? We have 102nd Constitutional Amendment Act 2018, right? So it was given the constitutional status to National Commission for Backward Classes, right? So this statement is correct. So it has the power to investigate and monitor all matters relating to the safeguard provided for the socially educationally backward classes, right? We have certain powers, right? So this amendment included 338B article, right? So we have 338 related to National Commission for SCs, right? So 338 we have National Commission for Scheduled Tribes A, right? 338B is for National Commission for Backward Classes. These three articles are very important. We have already discussed in the previous classes, right? So 338B was included by this amendment. The Commission submits its report to the President, who shall lay it before each House of Parliament. That is also very correct. So Commission is composed of a chairperson, vice chairperson and 3 other members appointed by the President. So all these statements are correct only. So D option is the correct. With reference to the office of the Chief Minister of a state, consider the following statements, right? So here office of the Chief Minister. So we have certain conventions. Apart from that, in Constitution we have certain enacted laws or provisions or amendments, right? So we have to carefully observe that, right? So Constitution specifies the procedure for the appointment and election of the Chief Minister. Is it mentioned? No. Not specified completely the procedure, right? So we have Article 164 clearly states that Chief Minister is appointed by or shall be appointed. Chief Minister shall be appointed by the Governor, right? So here we can say that Governor is selecting, or Governor is just selecting the leader of the opposition party, means leader of the majority party in the state legislature, right? So that is very important here, but not Constitution specifically mentioned this procedure, right? This is not correct. So Chief Minister can recommend the dissolution of the Legislative Assembly to the Governor at any time. Why? Because here CM is the head of the Council of Ministers, like PM, right? There in the central level, PM is the head of the Council of Ministers. On the advice of the Prime Minister, President can dissolve the Lok Sabha. Likewise here also state legislature relatedly they can dissolve the legislative assembly, right? So from the governor's or chief minister's recommendation, right? So this statement is correct, only 2 is the correct. Next, consider the following statements regarding the anti-defection law here. 10th schedule, very important. Previously in 2025 it was asked, right? So the law was added to the constitution by the 52nd Amendment Act 1985. That is completely correct, right? So decision on questions as to disqualification on the ground of defection is referred to the election commission. So is it election commission? So we have to carefully focus on these keywords, especially regarding the polity, especially why? Because there are a lot of confusion in between provisions or in between powers and functions, rules and regulations, etc. Right? So here the decision on questions as to disqualification of the ground of defection, anti-defection means here, so defection is referred to the election commission, not election commission here. So to the presiding officer, right, presiding officer of both our state legislature or we have Rajya Sabha especially, right? So here coming to Lok Sabha, that is the speaker, Rajya Sabha, that is the chairperson of the Rajya Sabha, right? So both are presiding officers of the two houses, right? So here one more important we have to focus on here. So this decision, whatever they have completely given to the presiding officers of both houses, is subjected to judicial review also, right? So this was completely mentioned in the case, that is Quixoto Holohan case 1993 especially, right? So Quixoto Holohan case 1993 especially mentioned that Supreme Court here. So it is the particular decision of on defection related, disqualification related or power of the decision given to the presiding officer shall be subject to judicial review, right? So the law allows a political party to merge with another party without attracting disqualification if at least 2/3 of its members agree to the merger. This is correct, right? So only this statement is not correct. Is 1 and 3 means only 2 statements are correct. Which one of the following statements regarding the Panchayat Raj institutions is not correct, right? So it is very important whether if you take the Panchayat Raj institutions or municipalities, one or two questions will become, right? So 73rd Amendment Act made the provision for the 3-tier system of panchayats at the village, intermediate and district levels, that was given by the recommendations of Balwant Rai Committee, right? Balwant Rai Mehta Committee, right? So very, very important. This statement is correct. So the minimum age for contesting elections to the panchayat is 25 years. It was mentioned 25 years was not correct. It is related to our state legislatures, right? Legislative assembly relatedly, they have this particular age, right? So here for panchayats it was 21 years only, right? So this is wrong statement. So all the members of the panchayat at the village, intermediate and district levels are elected directly by the people, right? So if you see the elections relatedly, so democratic government has the so many roots in the grassroots level of our local self-government only, right? So this is elected directly by the people, right? We have Gram Sabha, Gram Panchayat there, right? So the State Election Commission conducts the elections to the panchayats, right? So State Election Commission has the role and responsibility to conduct elections for the panchayats and also municipalities, right? So this is also correct. So Election Commission means Central Election Commission will deal with the Lok Sabha elections and also Rajya Sabha elections. Apart from that, we have state elections, right? So general elections completely. Apart from that, State Election Commission is completely related to the elections of conducting elections of panchayats and municipalities. This is correct. Only B is the wrong. So consider the following statements regarding the judicial activism in India. So apart from judicial review, judicial activism is also very important nowadays. So many are criticizing these courts or whatever we have judiciary, like judicial overreach, right? So that's why it is very important. So it is judicial philosophy that encourages judges to use their powers to correct injustice, especially in areas of social policy. So here judicial activism, the concept this judicial activism was not mentioned in the constitution, we have to understand. So this was just judicial interpretation, or we can say judicial innovation, right? So this explicitly mentioned in the constitution is not correct here, right? So if you see, the concept of public interest litigation is a major tool through which judicial activism is practiced. So people here are very much interested to know everything, right? So here, if you understand, the Supreme Court's use of due process of law concept is often cited as an example of judicial activism. We have already mentioned, like Maneka Gandhi case, 1978. So in this particular case, Supreme Court clearly says that this Article 21, right? We have introduced the due process of law to the Article 21, right? So here, from this particular situation, we can say the judicial activism is completely started in our India, right? So previously we have seen number of issues related to environment, right? So immediately judiciary involved related to that environmental damage, etc., right? So here only C, third statement is not correct. So only three statements are correct here. So next, with reference to the right to privacy in India, consider the following statements. Very, very important. So right to privacy, we have Supreme Court in the case Puttaswamy versus Union of India case declared the right to privacy as a fundamental right under Article 21. What is Article 21 here? So right to life and personal liberty. Here so many rights were included and also has been including day by day, right? So in future also they can include so many, right? So depending on the situation here, right? So right to privacy also here included under this particular 21, right? So this is correct. So the right is absolute and cannot be subject to any reasonable restrictions by the state. So whenever we have given certain rights, they are completely not absolute. Why? Because here if you observe, the absolute means here complete freedom. We have freedoms, right, but not complete liberty, right? Liberty is completely different from freedom, right? Freedom is having some restrictions, but liberty is complete freedom, right? So that is the major difference here. So we have only right to freedom only here, right? So here if you see, the right to privacy has some grounds. On those grounds state can restrict, right? So here what are the grounds? National security, we can say, and also we can say public order. Any sort of disturb the public order also, it has the restricted ground, right? So and etc., right? We can say dignity, morality of the whatever we have, our nation, etc. All those are some grounds on which state can restrict the right to privacy, right? So this second statement is called it is not correct, right? So only one is the correct. So next, consider the following statements regarding the constitutional amendment procedure, right? So it is very important, that was completely mentioned under Article 368, right? 368. So here a bill for the amendment of the constitution can be introduced in either house of parliament, right? It is completely correct, right? So introduction means a bill for the amendment of the constitution can be introduced in the either house of the parliament. That is completely correct. So bill must be passed in each house by a special majority, a majority of the total members. What is special majority here? For related to these type of constitutional procedures or money bill, we have to follow certain procedures, specific or special procedures. Those are special majority, a majority of the total membership of the house, and also 2/3 of the membership of the house present and voting. That is required here, right? So and also president must give his assent to the bill, and he can neither withhold his assent nor return for reconsideration. This statement is completely we have already discussed this statement previous questions, right? So article means 24th Constitutional Amendment Act 1971 clearly given this powers to the president, that is obligatory to give assent to the constitutional bills here. So he can neither return the bill for consideration, he can neither withhold the bill, right? So this is also correct. All these three statements are correct. All three are the correct. So next, which one of the following statements regarding the advisory jurisdiction of the Supreme Court is not correct, right? So Supreme Court has some sort of jurisdictions, right? So here we are talking about advisory jurisdiction. The President can seek the opinion of the Supreme Court on any question of law or fact of public importance, right? So if you have any issue related to fundamental rights or any public importance, Supreme Court can seek the opinion. President can seek opinion from the Supreme Court, right? So this is correct. Supreme Court is bound to give its opinion on any reference made by the President. So if you see this, completely not correct, right? Supreme Court cannot or not bound to give its opinion on any reference made by the President, right? President may ask anything related to other matters, but if you see, it is very controversial question here, we have to focus on that. So opinion of the Supreme Court, related to opinion of the Supreme Court, it is whether it is related to interests of the people or we can say public importance, on those matters only Supreme Court can give opinion, right? So but if you see, the opinion must bound to the particular Supreme Court, his case is pre-constitutional mandate. So pre-constitutional treaties, or we have some agreements, right? So on related to issues, these related to issues only, pre-constitutional treaties or agreements, related subjects or matters, Supreme Court is completely bounded, right? Bounded to give its opinion, right? So that is the main important, or not bound to give its opinion. Why? Because Supreme Court, it was at that time it was not completely related to that constitution related provisions, etc., right? So Supreme Court is not bound, sometimes is bound to give and also sometimes not bound to. This is very controversial statement, but in specific it is general statement only, that's why we are taking it is not correct, right? So it is always means it is bound to give its opinion, any reference made by the President means it is not correct, right? Opinion given by the Supreme Court is not binding on the President also. So whenever Supreme Court given some opinion, President may not consider, right? So that is just opinion, not obligation, right? So this is not binding on the, it is also correct. Provisions for advisory jurisdiction is contained in Article 143 of the Constitution. If you see the Article 143 Clause 1 clearly says that any public importance, Supreme Court can give the, is bounded to give the opinion of the Supreme Court, right? So to the President, right? So likewise, if you see the 143 Clause 2 on specific related issues, right, pre-constitutional treaties or agreements, Supreme Court is not bound, right? So it is related to these two provisions only, the difference between these two provisions only we have to make the choice, right? So only here B is not correct. Next, consider the following statements regarding the national emergency here, Article 352. This was also discussed in the previous classes. So a proclamation of national emergency can be issued on the grounds of war, external aggression or armed rebellion, right? So if you see the armed rebellion, so it was previously internal disturbances only, right? So this was changed in the after the 44th Constitution Amendment Act 1978 only, we have changed this to armed rebellion, right? So this is correct. So the proclamation must be approved by both houses of parliament within 1 month by a special majority. Is it correct? Yes, for national emergency we are talking about, right? So 1 month is correct. If you take state emergency or financial emergency, that is 2 months, right? So once approved, the emergency remains in force for a maximum of 6 months. So after 6 months they can continue, right? So every time they have to provide approval, give an approval from the parliament, right? So President can revoke the proclamation at any time by a subsequent proclamation which does not require parliamentary approval. So whenever we wanted to proclaim the national emergency, we have to take permission from parliament, but to revoke the national emergency, President no need to take any permission, right? So that is correct. So if you see the all statements here, all 4 statements are correct. D is the correct. So with reference to the provisions of local self-government in the 5th schedule areas, consider the following statements. So if you see the 5th schedule, so 5th schedule, schedule 5, completely given the powers, some special powers are special responsibilities to the governor, right? So related to scheduled areas or scheduled tribes areas are of certain states, any state, right? Other than we have certain states not related to the schedule 5, those are related to schedule 6 only. Assam we have Meghalaya and Tripura we have, right? So and also Mizoram. Except these 4 states which are covered under 6th schedule. So here governor is completely having the powers, right? Powers to govern or administer or control the remaining scheduled areas or scheduled tribes, right? So here the governor is empowered to direct that any particular act of parliament or state legislation shall not apply to a scheduled, right? So from this provision, so completely it is giving schedule 5 providing some considerations of providing from some powers to control, right? So here whether it is central act or state legislation, he can modify or he can change, right? So depending on the situation. The governor is required to submit a report annually to the president regarding the administration of the scheduled areas in the state. So this was also mentioned in the schedule 5 norms or regulations or rules and regulations, right? So he has to submit the report, annual report to the president, right? So both two are the correct here. So next, consider the following statements regarding the parliamentary privileges here. So parliamentary privileges explicitly mentioned, define the privilege of the parliament and its members. This is not correct. Why? Because it is a convention only. We have been following from the British House of the Commons, right? So from those times only we have traditionally or conventionally we have following, but not explicitly defined in the constitution, right? So privileges are available to the Attorney General of India as well, right? If you see the article 88, right? So these ministers or attorney generals has the some additional powers, means they can participate in any court, or they can like attorney general, law, highest law authority in India, he can participate in any proceedings of the court or houses, right? So that is the power, but cannot vote. That is the application. The parliament has the power to punish any person for breaching its privileges for contempt of the house. This is mandatory. These privileges have to be used properly by the members or ministers or attorney general, like, right? So first statement, except first statement, both are true, correct. So which one of the following statements regarding the fundamental rights is not correct? Very important here. So fundamental rights available against the arbitrary action of the state. So in the constitution, state having some responsibilities to govern the people, and also citizens also having some rights, right? So to control the state also, right? So here both are having some relationship between state and citizens. We have so many provisions here, right? Fundamental rights, especially whenever the violation of the fundamental rights happens, Supreme Court immediately, means judiciary will intervene, right? So like that, so they are available against the arbitrary action of the state, right? This is correct. So they are absolute and not qualified. We have already discussed related to Article 21, but here, so coming to the fundamental rights here, complete fundamental rights, they are not absolute here, right? So they are qualified only, not absolute here, right? So here why? Because already we have right to freedom, right? So right to freedom, regarding the right to freedom, we have already discussed in the previous classes regarding 19 article, right? So there were some grounds on which state can impose restrictions to the freedom of movement or restriction, etc., right? So here what are those grounds here? National security, or we can say the public order disturbance, or we can say the dignity or morality, etc., right? So they are justiciable, allowing persons to move the courts for their enforcement, right? So for the violation of the fundamental rights, we can directly move to the Supreme Court. No in between courts, we no need to go to the High Court or District Court, etc. We can directly move to the Supreme Court on the violation of the fundamental rights. That is correct. They are defended and guaranteed by the Supreme Court, right? So both statements are same one. So except this second, B is not correct. So consider the following statements regarding the Council of Ministers at the union level. So the advice tendered by the ministers to the president cannot be inquired into by any court, right? So these advices are very much important here. Advice tendered by ministers to the president cannot be inquired into any court, right? They are completely binding only, right? The council of ministers is collectively responsible to the Lok Sabha. So if you use this statement, that is completely written in the article 74, clearly stated this, right? So the prime minister, or here president, has to follow the advice of the council of ministers that was headed by the prime minister. So council of ministers is collectively responsible to the Lok Sabha. It was mentioned in the article 75 clause 3, right? So the total numbers of ministers including the prime minister shall not exceed 15% of the total strength of the Lok Sabha here. So if you see, this particular notion or principle was added in the 93rd Constitutional Amendment Act, right? So we can add 2003, right? Very, very important. So apart from that, a minister who is a member of one house of parliament has the right to speak and take part in the proceedings of the other house. So this is very much important provision mentioned. If you see the article 88 regarding the attorney general, we can see as an example here, right? So all these statements are correct. So here 4 is the correct, right? All 4 statements are the correct. With reference to the writ of quo warranto, consider the following statements. So it is issued by the court to inquire into the legality of the claim of a person to a public office. What is the meaning of quo warranto? By what authority? Means public can ask the authorities, public officials, by what authority you are working here? What are your responsibilities here, right? So likewise, writ of quo warranto, if you compare with all the writ jurisdiction here, so everything is completely given by other personalities, but here completely from the public point of view or public interest point of view, we can say the quo warranto is very important. It can be sought by any interested persons and not necessarily by the aggrieved person. Why? Because public may interested in the legality of the public office, right? So it is both two are the correct. Consider the following statements regarding the directive principles of state policy here. So they are non-justiciable in nature, meaning they cannot be enforced by any court. So if you see the fundamental rights and DPSPs, there are a lot of differences. They are enforceable. Fundamental rights are enforceable. Why? Because whenever there is any violation of the fundamental right, again we can directly go to the Supreme Court, right, on state actions, right? So likewise, DPSPs are not mandatory here. DPSPs, we have to follow certain principles. State has to follow certain principles to give socio-economical justice to the citizens, right? So they are not obligatory or non-justiciable in nature. They aim at establishing a political democracy in the country. So already we have seen the, if you see the DPSPs, differences between DPSPs, if you see the DPSP here, they are only socio-economical democracy only. It will uplift the socio-economic democracy in India, right? So, but if you see the political democracy here, right? Political democracy relatedly, we have fundamental rights, we have preamble, or we have a parliamentary form of government. All these were related to the political democracy in India, right? So they were borrowed from the Constitution of Ireland, right? So we have just borrowed the directive principles of state policy from the Irish Constitution, right? This is correct, but this is not correct. So 1, 3 means only 2 are the correct. So the concept of cooperative federalism in India is best promoted by which of the following bodies? This is very interesting question here. If you see the options, all are promoting the cooperative federalism only. So from the UPSC perspective, we have to carefully focus on the keywords, each and every keywords mentioned in the question, right? So India, the concept of cooperative federalism is in India is best promoted, right? They have asked best, right? By which of the following bodies? If you check, all these are promoting cooperative federalism only in any case, right? Including their powers and responsibilities, etc., right? So but here if you see the interstate council, it is only the constitutional body, right? Constitutional body that was established under Article 263. It is completely promote the cooperative federalism wherever it is related to issues between the state, among states or in between center and states, it will have the choice, right? So role played by the interstate council, right? So it is a constitutional body, that's why we are indicating the best promoted by the cooperative federalism by the interstate council only. B is the correct option. So next, which one of the following statements regarding the Public Accounts Committee of the Parliament is not correct? So Public Accounts Committee, it is completely a convention, right? So convention we have been using from the 1967 itself, right? So it examines the annual audit reports of the Controller and Auditor General of India. It consists of 22 members, 15 from Lok Sabha and 7 from Rajya Sabha. And chairman of the committee is invariably appointed from the ruling party. This is not correct. Opposition party only. The Public Accounts Committee members, all committee members are coming from the opposition members only. That was the not mentioned in the constitution, but we have been following from the convention, right? Means 1967. A minister cannot be elected as a member of the committee. Yes, from this second means C statements only we can say that, right? So ministers cannot be participated in or elected in the member of the committee, completely opposition party only here, right? So this is cannot be elected as a member. This is correct. Only C is the correct, not option, not correct, right? So next and last question, with reference to right to constitutional remedies, Article 32 consider the following statements. It is completely related to writ jurisdiction of the Supreme Courts and High Courts. If you see the Supreme Court having related to the enforcement of the fundamental rights, Supreme Court having this Article 32, power of the enforcement of the fundamental rights. Article 32 is the writ jurisdiction of the Supreme Court. If you see the Article 226 here, right, that is completely related to High Courts writ jurisdiction, right? So it is completely related to Article 32 only. If you see the statement wise, each and every statement here, so Supreme Court has the power to issue writs for the enforcement of any legal right. It is completely related to the writ jurisdiction of High Courts, not Supreme Court. So this is only issue writs for the enforcement of the fundamental rights, not legal right, right? So this is not correct here, right? So it is a fundamental right that can be suspended during national emergency. That is fact, right? So these fundamental rights also suspended during national emergency, state emergency. Right to move the Supreme Court under Article 32 cannot be taken away even by the amendment to the Constitution, right? So here, if you see the right to move to the Supreme Court under Article 32 cannot be taken away by the amendment to the Constitution. This is the completely mentioned on the Article 368. If you see the basic structure of the doctrine, right, that was mentioned, Keshwan and the Bharati case here, 1973, right, basic structure of the doctrine. So we have some provisions here. So Article 32 is a basic feature of the Constitution also, right? So it is a basic feature of the Constitution and fundamental feature of the Constitution. So for that, Supreme Court under Article 32 cannot be taken away even by the amendment to the Constitution, right? So here only the first statement or second statement is not correct. So 1, 2, 3 means only 3 statements are the correct here. So these are the 25 questions for the explanation part of the Polity test 2. So just one key mistake was there. I think the third question, please rectify it, right? So we will check the next test 3. We will see and discuss. Thank you very much. All the very best.